Good afternoon, this is Greg Lois. Thanks for joining in today. We're going to be talking about how we weaponize initial discovery in New Jersey workers' compensation cases. And my intention today is to also put some kind of renegade ideas out there and talk about how we're going to get our cases moving in a positive direction in a jurisdiction that just seems almost resistant to moving forward. If this is your first time joining, hi, my name is Greg Lois. I'm the managing partner of LOIS Law Firm. We are a workers' comp defense firm. This is all we do. We are about 55 attorneys. All we do is defend employers in workers' compensation actions in New York and New Jersey. New Jersey is near and dear to my heart. I love New Jersey workers' compensation. In fact, it's where I started as a workers' comp attorney about 10 years ago. We're coming up on our 10th edition. I was asked by LexisNexis to be the co-author of what is the handbook, the practice guide to New Jersey workers' compensation law. There's two authors, me and Rick Rubenstein. Rick's a plaintiff's attorney, I'm the defense attorney, and we're the co-authors of this book. And the reason I'm bringing this up is because I have a love affair with the rules and the law in this jurisdiction, and I love sharing these ideas, but I've become quite frustrated in the last few years with workers' compensation defense, both as a practice and, by the way, other practitioners and even the judges are applying these laws and rules. And so today I'm going to talk about discovery, which might seem like kind of a dry topic, but I'm going to talk about some ideas that we can use to move these cases forward and hopefully give some practical tips. I've got a couple renegade ideas that I'm going to throw out there today, some sort of atomic bombs that we can lob. And I'm looking for clients who are interested in doing things to get these cases moving forward differently. So let's just talk about why this presentation is being created today. And I just want to tell you a little story. Now, you know, all lawyers, we're all storytellers. We love to tell tales, particularly where we're the hero of the story. But this is a story where I don't feel like a hero, and a lot of the thinking about how I was going to approach this topic was going to be formed. So this came up recently in one of our cases. We have a case, the petitioner worked at a facility. He says that he got injured roughly in June or April or so of last year. And he says he got injured by walking around, and he says he stumbled on the carpet. There was some loose carpet allegedly, and it hurt his knee. So he goes and finds a workers' compensation attorney. He gets no medical care, as far as we know. About 6 months later, he goes and finds a friendly attorney at law who's going to file a workers' comp claim for him. They file the workers' compensation claim, saying that he injured his knee by walking across the carpet, and no medicals are turned over. So at the time of us filing our answer, we demand that they provide us with any unauthorized treatment records. Nothing is provided to us. Ultimately, we filed a motion to compel. We said, look, you filed this claim petition saying that the guy was injured. He didn't tell anyone at work. 6 months go by. You said that 6 months later he went and got some medical care and hired an attorney. Turn over the medical records. He doesn't turn over the medical records. Instead, the petitioner files a motion for med in temp, attempting to take control of his own medical, and it's supported by the IME report of a medical expert that he hired. And in the IME report, which supports the motion for med in temp, the doctor who wrote the opinion says, oh, I reviewed all these medical records that were provided to me, and actually lists out the medicals that they reviewed in coming to their opinion, which of course was that he had a causally related injury and that his need for treatment was related to that injury and that we should provide that treatment. Well, that's not fair. We filed a motion to compel. The judge did not grant the motion, also did not deny the motion. And so we looked at this case and we said, well, this is not fair. Obviously their IME doctor had medicals, so how are we going to get them? Opposing counsel won't give them to us. So we subpoena the IME doctor and say, please provide us with all of the medical records that you reviewed in reaching your opinion as to medical causation and need for treatment. Petitioner's counsel got upset about this and said, Judge, they subpoenaed this doctor. You shouldn't allow that subpoena to stand. Asked the judge to require us to withdraw the subpoena. The judge says, well, I don't appreciate it when people issue subpoenas in my name. And so, Mr. Lois, you need to withdraw your subpoena. And the judge says, I'm also going to let this motion for med intemp to proceed. Now, of course, our arguments are, wait a second, petitioner's counsel has unclean hands here, Your Honor. This is not fair. How are we supposed to defend a case in which the claimant goes out, gets medical care on their own, unauthorized treatment? We make a valid demand that they provide us with that information. Then they refuse to turn it over. We file a motion to compel them to do so. Your Honor does not grant the motion, and instead what they do is file a motion for med intemp based on an IME opinion based on that same medical that they withheld from us. Now, if this sounds like me whining and complaining, it's because this drives me nuts. It infuriates me. This is just not fair. This is the definition of unfair. And so there's some big conclusions that I want us to draw. First, opposing counsel often will flagrantly disregard their discovery obligations to us. The second thing about our system is judges routinely avoid deciding these motions. We make motions to compel discovery not because we're going on fishing expeditions, because we actually need that information. Another thing that's been happening more and more in the division is the judges intervening or in some cases asking defense counsel to withdraw subpoenas. And some, and this judge in this one instance, demanded that we ask the judge in advance for their individual permission before we even issue a subpoena. Now, obviously, this creates unnecessary delay in this litigation, and that, of course, is justice denied. My clients are paying costs for us to bring motions, to make these appearances, and the other side is just hiding medical records. I mean, it's so flagrant, it's so obvious. And the other thing we see in this jurisdiction a lot is judges routinely granting adjournments to opposing counsel, to plaintiff's counsel, to petitioner's counsel, without them having to show good cause. In other words, a case is listed for a pretrial conference, and we're ready to go, right? And opposing counsel says, Judge, can I get an adjournment? We're not ready. And the judge just grants the adjournment with no, hey, why? What is not ready? I mean, in this case in particular, were you looking for medical records? No, you were clearly sandbagging, hiding medical records, getting an IME opinion so that you could file a motion for med intemp. It probably brings me to a broader point, which is the misuse and abuse of the motion for med intemp in this jurisdiction. So if any of this stuff sounds familiar to you, if you are a respondent or an insurance carrier and you say, why is everything getting adjourned in this jurisdiction? Why does it's so hard to get traction in these cases? Why aren't these cases moving forward? Why is everything in New Jersey take so darn long? You're not wrong. The jurisdiction is not following its own rules. And I'm not just, again, saying that as someone who's frustrated about an outcome in one case. I'm someone who's literally written the book on how the system is supposed to work and what the law and the rules require, and felt stymied myself. And so today in this presentation, we're going to talk about discovery obligations. We're going to talk about the responsibility of both sides to not proceed by way of trial by surprise, to trade information. But I'm going to talk about how that gets thwarted and what we can do about it. I'm also going to suggest some rather radical ideas, things that are going to make people feel uncomfortable when I do them. But hey, this is the signal. I am at this point so frustrated that going forward, you're going to see me litigating these cases in a different manner. So here's what I'm going to talk about today. I'm going to talk about what kinds of discovery we're entitled to as the defense, as the employer, as the carrier. What are we supposed to be getting? What kind of information do we have an obligation to turn over? What do we do when the other side doesn't cooperate? And what do we do when the judge refuses to follow the law and refuses to grant our motions? I'm going to provide you today with some radical tools and opportunities that I want you to use in your cases right away. And by the way, the second idea I have here, hint, hint, it's called the writ of mandamus, is so belligerent that it will brand me forever as a renegade for even talking about it. But I am going to be deploying this in the coming months. I'm going to do this in the spring to see what kind of reaction I can possibly obtain and hopefully get some traction from my clients. I honestly and deeply in my heart, even as someone who sells his time and attention as his stock and trade, in my heart, it hurts for some of my clients because the courts move so slowly and there is so much delay in this system, unnecessary delay in my opinion, and there is so much, I'm just going to call it malfeasance, where judges just refuse to fulfill their obligations, that we have to do now radical things. It's 2025. I've been writing the book for 10 years. I've been telling people how it's supposed to work for a decade. So fair warning, we're going into the next mode, okay? If this sounds interesting to you, I'm glad you're here today. I did put a copy of the entire book in today's handout, so you're welcome to read it. By the way, wow, what a great stocking stuffer it makes. If you're ever at the beach, you know, and you've got a nice pina colada in your hand and your feet are in the sand and you need a great book to read, I mean, I think this thing's a real page turner, but I might be alone in that. And so really what we're going to look at today is chapter 4, which is on pleadings and initial discovery. And I'm going to talk a lot about what we do in the discovery process, what's the point of it, what are we trying to get to, how is the system not working, and how can we make it work better? My job as a defense counsel is to get great results for my clients, the best results I can get. Oftentimes that's just creating as much leverage or opportunity for my client as possible so we can move a case to conclusion as fast, as quickly, and as efficiently as possible. In this system, it is very hard to do that because of the way the system is not just organized, it's actually organized in a way that the law is structured in a way to move cases along, but the way that it is being managed is what is such a big challenge. So, today we're going to talk about what are the different discovery devices we have, how we use it tactically, and why we're doing this, how we're going to use our discovery to get ready for the expected trial. Now, pleadings and initial discovery is our opportunity to avoid surprise. There are discovery timelines, and we can utilize them to perhaps move cases along more quickly, and of course, to preclude unwanted proofs from coming in later. Now, I'm going to talk about a technique where if the judge is standing in our way of getting to a resolution, we will try to either elevate that issue to a supervising judge or even the chief judge, and we can use writs, equity writs, to move cases forward. So let's talk through the basic request for discovery. Now, if you're wondering where the authority for all of this comes from, there is a statute that controls the way the law is supposed to be applied, and then there are regulations that are issued by the Division of Workers' Compensation, which is part of the Department of Labor. And those regulations are basically the rules of court. And those rules of court are freely downloadable. You can go to the New Jersey Workers' Compensation Division's website. You can download them in different formats. I live with a copy of the rules on my desk at all times because I'm citing to them so frequently, and they are supposed to control, the basics of how we exchange information, what are the order of proofs at a trial, what kind of things can a judge do when a motion is filed. All of those things are found in the court rules, which are in the regulations, not in the statute. So that's really going to be the source for a lot of today's authority. So the first thing is, there is a timeline for discovery that is encapsulated in the rules. And the rules say that all discovery shall be concluded. Now, the word shall is important. Shall means must, okay? It doesn't say discovery may be concluded or maybe you can do discovery. It says it shall be concluded. And so that's a command. That's a rule that the judge has to follow. So all discovery shall be concluded within 180 days from the filing of the respondent's answer or from petitioner's last authorized medical treatment, whichever date is later. Now that's important. The rule says discovery has to be concluded within a certain timeline. 180 days, it's roughly 6 months from the time we file our answer or from the last time that we provide authorized care. Now that's important, and the reason that's important is because where later on in the case, and these cases drag. So a year later, all of a sudden petitioner's counsel starts bringing forward, oh, here's some new medical we just dug up, or here's a report we found. We can exclude that. We should make the argument like, well, I'm sorry, the time for that to come into the case is over. You're past the 180 days, so no thanks. It also means that opposing counsel cannot make a demand of us to turn over information or perform investigations or do other things. That 180-day period of time, it runs against both parties. So the other side can't be forcing us or demanding that we turn over things later either. And the whole goal of this is to avoid a surprise, and it's to control that period of time. So that's important for us to know, that there is this timeline that we're working against. Now, the rules contain all of the discovery methods that are supposed to be utilized, but there are enumerated discovery methods that are laid out in the statute, and they're common ones, and you should see these in all of your cases. First, we're entitled to all medical records held by the other side. We're also allowed to demand answers to interrogatories in certain cases. We're allowed to issue subpoenas under Section 56 and Section 60 of the statute. We're also allowed to demand a statement of pre-existing conditions. And then there's some additional discovery that we're allowed to do. If the claimant is going to die before the case is going to be resolved, we can demand their deposition. So, depending on what kind of case it is, we're going to be thinking about which of these discovery sort of tools that we're going to deploy. In every case, even an admitted case, we're going to serve discovery demands on the other side just to make sure we're not surprised. We're going to also serve HIPAA releases, and we also add a statement of Medicare entitlement. And this is sort of belt and suspenders, because in every claim petition, the petitioner has to reveal to us if they are currently a Medicare recipient. Now, the other thing we want to do when we're thinking about our discovery needs is we want to be proactive about this. The whole point of this would be for looking for reasons to exclude or preclude the petitioner's medical expert if they rely on information that was not turned over to the defense previously or within the discovery period. So let's start with medical records, because this is where we get into so many fights. Each side has the burden to provide copies of medical records to each other. And we make a demand in every case that the petitioner provide us with copies of any unauthorized treatment records. If you think back to the story I started talking about at the beginning of this presentation, obviously petitioner's counsel had medical records that they were withholding from us. When that demand for them to produce medical records is given to them, they must respond within 30 days. And the same thing applies to us. We have to respond to requests for production of medical records. And we affirmatively, my firm, we affirmatively try to get on top of this. As soon as our client sends us medical records from authorized treatment, we are putting them into a medical index, and we keep resending that index to opposing counsel as the case is progressing. I actually want to keep opposing counsel as up to speed and up to date with what's happening on the medical side of the case as I can, because remember, once they reach maximum medical improvement, then both parties should be ready to schedule the petitioner for permanency evaluations. Because remember, in New Jersey, it's an impairment state. So in every single case, petitioner's counsel is going to collect a medical expert's opinion that's going to say that all this medical care you provided didn't actually make the person better. In fact, it made them worse. Their medical impairment's horrible right now, and you should pay them a giant award. That's how this system works. Now, in addition to medical records, interrogatories are also allowed to be served. What are interrogatories? It's just lists of questions that we ask the petitioner to respond to. And in certain cases, we're allowed to do this without filing a motion or seeking leave of court. And the types of cases we're allowed to do this are typically what are considered more complex from a causal relationship point of view. So occupational exposure cases, think about your respiratory claims, your repetitive or cumulative orthopedic trauma cases, your carpal tunnel, cubital tunnel syndrome cases, your overuse injuries, you're allowed to serve occupational interrogatories. Same thing with death or dependency claims. Usually the causation is questionable. And for that reason, we're allowed to serve interrogatories without motion. And the same thing for reopener claims. Unfortunately, I keep saying unfortunately, but New Jersey is rampant with reopeners. If you're defending cases in this jurisdiction, you know petitioners love to reopen their cases. Something like 1 in 5 cases pending before the Division of Workers' Compensation is a reopener, in which the petitioner is alleging that they had a material worsening of their medical condition and they are therefore entitled to more compensation. So those are typically brought in after an order approving settlement has been reached or even a judgment has been reached. And roughly 20% of our caseload is defending reopeners. Now, you can file a demand for interrogatories in any type of case, but you might have to file a motion to compel the other side to do it. So medical provider claims, cases where it's an admitted accident, but there's something about the incident that we want to investigate, or any other reason to craft interrogatories. You know, there's maybe the person has a pre-existing that you want to explore, or you believe that there's a work ability or that they're working in other places. You want to find out information about that. So you can craft custom interrogatories really for any reason, but you don't get those answers automatically. You have to file a motion typically to get the other side to respond. Now, when we get responses to our interrogatories, our role here is to review them and try to resolve any issues I find in the interrogatory responses. And believe me, opposing counsel is quite clever at avoiding giving us information in their interrogatory responses. When I say, how did the injury occur? And their response is, it occurred at work. That's not enough. That's evasive. That's too vague. It's hopeless. They're not giving me any information. So oftentimes we'll file a motion to compel them to provide more specific answers. And that is a typical motion that we have to bring. Now, another power we have, a discovery power, is to issue subpoenas. This is specifically allowed by the statute. And the statute says that the subpoenas have to be served in a way that is consistent with the civil court rules. Now, generally, we try to make the subpoena returnable on a list date or any other date that makes sense. The case law on this just says that a subpoena response date should be reasonable. So there is no, it has to be 20 days from now or 80 days from now or 90 days. It says reasonable. Obviously, if I contact a doctor's office by way of subpoena and say, you need to provide me with all records in 24 hours, that's not going to be deemed reasonable. So it needs to have a reasonable timeline. And we like to use the next pretrial conference as the date of the return date. Now, some judges have expressed a preference to me. They said, Greg, I don't want you to sign subpoenas in my name, which is what we typically do. I want to sign my own subpoenas. Now, there is absolutely no authority for judges to do this. In the civil courts, and by the way, it's the civil court rule that applies in this instance, we regularly issue pro forma subpoenas that are issued in the name of the presiding judge. We just do that all the time. You don't call a court and ask for permission to do that. But workers' compensation judges seem to believe they have this power and will sometimes push back and say, you shouldn't have issued that subpoena because you didn't run it by me first. Really, Judge, that doesn't make a lot of sense. It's not required, but it is some judges' preference. And again, now we're getting into the places where the judges are doing things that are extra statutory. What kind of things can you receive in response to a subpoena? Well, the case law says a subpoena should be specific, narrow, and tailored to information in your case, okay? And really what we're trying to avoid here is going on crazy fishing expeditions. That's not the point of subpoenas. The Workers' Compensation Act specifically says that the subpoenas we issue have to simply conform to the civil rules and procedure. We serve them via certified mail in most cases. Where that fails, we will then serve them by way of personal service. Now, what can we get in response to a subpoena? Well, the answer is you can compel much more than just the production of records or the testimony of a witness. You can actually make or require that the subpoenaed party produce something, right? So it's not uncommon for us to say, well, we need you to produce a list of all of the dates that this person worked for you. Or we need you to produce a payroll summary of all the amount of money that this person made. That would be an issue of concurrent employment. You can make the recipient create a new record that answers the subpoena, as long, again, as it is narrow, tailored, and focused. And of course, going to produce information or data that's going to be relevant to your current case. We're really looking for parole evidence, stuff that is going to be admissible in court. That's a good thing about subpoenaed information. Because it is subpoenaed under seal of court, and the testificant has to return it to you with their affidavit saying this is the complete record, it's generally easy to introduce it as evidence in your workers' compensation defense. Now, subpoenas are enforced by an order of contempt. And interestingly, a workers' compensation judge does not have the statutory authority to issue a contempt, except for when it applies to subpoenas. So if a party is being non-compliant with a subpoena, the judge can threaten them with a contempt proceeding. You can also use subpoenas to compel the production of witnesses or testimony. And I want us to be very careful and thoughtful about how we do this. Where we are going to use a subpoena to compel testimony, just be warned. If you're using it to secure the testimony of your own witness and your own witness does not appear, the judge can take a negative or adverse inference because theoretically that was a favorable witness to your case. So we want to be really tactical about using subpoenas ad testificandum. I generally will not use them to secure my own trial witnesses because, again, if the witness does not appear for any reason, the judge can say, well, they're precluded, and I'm going to take a negative inference. So just be very mindful about how we use it. Now, will I use a subpoena ad testificandum on opposing parties' witnesses or maybe a rebuttal witness that I have? Absolutely, and I will serve that tactical purpose quite well. So just be thoughtful about that. Now, what if the opposing party, remember every time I issue a subpoena, I have to send a copy of it to my opposing party, says, we don't think this subpoena is appropriate or proper. Well, opposing parties can object to subpoenas by quashing them, which is, just filing legal opposition. And they would file that legal opposition, by the way, before the workers' compensation judge. Once that motion to quash the subpoena has been filed by opposing party, our party or the party that we've subpoenaed should be instructed not to respond until the objection is decided by the judge. Now, my admonition to all the practitioners out there, I know there's lawyers watching this presentation, is do not allow in-court opposition. In other words, you've issued a subpoena and you've said, okay, the subpoena is returnable on February 3rd. Produce the information by that date. And you go to court and the opposing counsel stands up and says, Your Honor, I want to oppose that subpoena. I'm sorry, it's too late. All opposition to a subpoena must be in writing and must state the legal basis for the objection. So in court or verbal opposition to a validly served subpoena is itself defective and should not be considered or is not grounds for the judge to overturn the subpoena. And that's one of the frustrations where the judge is not allowing the process or not following the legal process which is set forth in the statute and the rules. Another powerful tool of discovery in New Jersey workers' compensation cases is the requirement that the petitioner must provide a statement of pre-existing conditions. Absolutely important for us in determining if there's an opportunity for apportionment. Okay, this does not take the place, by the way, of getting a good ISO prior claims history. This is something you would use to supplement or maybe test that ISO statements of pre-existing claims history. So you can ask them to produce a statement of pre-existing conditions. At LOIS, our intake procedure is to serve this in every single case, no matter how minor. Technically, though, the petitioner does not have to respond to the demand for statement of pre-existing conditions unless the claim alleges that they are totally and permanently disabled. All right, but how many cases start off with it starts off as a leg case or a thumb injury, and 2 years later they're claiming, well, I also have a thumb and now my back aches and I have depression and anxiety, so now I am permanently and totally disabled. Well, guess what? If you didn't already serve that demand for the statement of pre-existing conditions, and it's more than 180 days since you last provided that last authorized treatment, you might be out of time to make this demand for a statement of pre-existing conditions. So we always serve it in every case protectively, okay? It's also one of these things when I take over a case, when I substitute into a case because it was handled by prior counsel, I always check to see if they issued one of these. They rarely do. And I try to reissue discovery demands that have been skipped by lazy counsel at the time of substitution. So once you receive a response to your demand for statement of pre-existing conditions, we are going to go after and try to find as much information as we can. I also think even a negative response is sought after. So when they say, I've never had a pre-existing condition, well, that's useful for me to know. Maybe it will help me avoid doing unnecessary discovery or searching after records that might not be useful. But it also might help me create a fraud defense of concealment. So if they respond to my statement of pre-existing conditions, say, oh, I don't have anything, I'm fine, then 2 years go by, and now we discover all of these pre-existing conditions which maybe impact the defense of our case, I will raise fraud under Section 57.4 of the Workers' Compensation Act, arguing that they are concealing a prior condition. So it can have a strategic impact on your case. In general, where they have revealed that there were prior conditions, we are going to serve HIPAA releases and try to secure those medicals. Now, I'm going to talk about this very quickly. I've been doing workers' compensation defense in New Jersey since 2001, so this is a long time, 24 years. And I can tell you, I can count on one hand how many times I've taken a deposition of an infirm petitioner. Usually it's done to preserve testimony where the petitioner is going to die. It is just so rare, it's not really worth talking about. Again, opposing counsel can oppose our demand for a deposition, but again, it's going to be rarely done. All right, what about any additional discovery methods, things I haven't already talked about? Well, there are some judge-crafted discovery methods that are possible. In other words, the judge can agree that, hey, the parties should issue supplemental interrogatories. That's new lists of questions for the parties to answer. A judge can allow deposition of witnesses. I think they should be doing this more often, particularly where it's who employed this person. Well, let's go sort all that out and come back and provide the testimony to the court. And the judge can also make a rule that the parties have to respond to specific interrogatories. This is sometimes happening in the context of medical provider claims. Now, a little practice point for the attorneys out there, just because a judge directed discovery on their own doesn't mean it's not objectionable. You could still put an objection, I would do it on the record, so that you're creating a record for appeal, particularly where the judge is going to be directing discovery outside of that statutory 180-day timeline. Generally, out-of-court testimony or witnesses is disallowed by statute. However, what's interesting about this is so many of our cases have a risk transfer opportunity. So the claimant is making a civil claim for injuries or disabilities or pain and suffering that's arising out of the same accident that forms the basis of the workers' compensation case. Well, I love to get the deposition transcripts that have occurred in those other cases and see how the petitioner testified and what they testified to in those cases. You can certainly utilize those to cross-examine or maybe rebut the testimony of the petitioner in your workers' compensation case. Lastly, what happens when opposing counsel is not turning over discovery to you? And believe me, I think that that's one of the most common barriers to moving cases forward quickly is where petitioner's counsel doesn't want to do a lot of legwork. It's an occupational exposure case where proofs are quite tenuous, or there's subjective claims or all sorts of reasons, and they just want to slow both things. I think the first example I gave when we started this presentation about the attorney who was actively hiding medical records, I mean, clearly actively hiding them, that's probably more rare than just the lazy plaintiff's counsel. You know, plaintiff's attorneys are really good at signing up lots of cases, but maybe not always so good at moving them down the field. And so we have to file what's called a motion to compel discovery. Now, when we file these motions, we should also reference the section of the rules which say, once a motion is filed, it, quote, shall be considered uncontested unless responsive papers are filed and served within 14 days of the service of the notice of motion. Okay, that's coming right from the New Jersey Workers' Compensation court rules. What this means in plain English is that unless written opposition is filed in a discovery motion within 14 days of you filing it, the judge must grant us the relief requested. That's not the judge may, or the judge, if they feel like it, will grant it. It says the judge must. Okay, that's what the rule requires. And that's one of the chief frustrations. We're here trying to defend these cases. We're trying to push people to maximum medical improvement, get them to permanency, and close these things out. Opposing counsel dragging their feet, not doing what they're supposed to be doing. Well, the statute has something we can do. We can file a motion to compel that discovery. But where the judge doesn't require them to actually oppose the motion, the judge should just grant the motion. My belief is that justice delayed is justice denied. And New Jersey has a lethargic pace of litigation, and it's offensive. I actually feel bad for my clients. I do everything I can to push these cases forward as fast as I can, but the courts really don't seem to care. Opposing counsel often do not oppose discovery motions, and judges still rarely grant them. And they often will allow verbal opposition to be given at motion hearings. I can tell you, I'm a very experienced practitioner. I appear at motion hearings and say, Judge, I filed a motion to compel. I've been asking for this information. I'm asking. I finally had to file a motion. Opposing counsel will appear and go, oh, sorry, Judge. Could I have a few cycles, cycle is 3 weeks, to respond to that? And they're not saying respond to it like give Greg what he wants. They're like, maybe I'll respond to his motion. And the judge will go, okay, take a few adjournments. And it just slows everything right down and frustrates. And what I've seen too is judges attempting to curtail the use of subpoenas in our discovery power, where it could develop relevant, important evidence in cases, and that also slows down. So what do we do about this? And in my opinion, by the way, I feel like it's gotten worse, okay? COVID lockdowns were an excuse for why things were slow 5 years ago. Now they're just still at that slow, crazy, weird pace and getting slower. And it's frustrating, particularly for me. You know, I only have so much attorney capacity, and these cases just back up and they're not moving. So what can we do about it? So I've got two ideas. First, I'll tell you, file those competent motions. File them when you need to, when they're not fishing expeditions. They should be supported by a certification of counsel. Where they are not opposed, your counsel should be filing 14-day letters. Here we have a template that we use that says, hi, I filed a motion 14 days ago. 14 days has elapsed. I've gotten no response. There's no opposition filed. Your Honor should simply grant the order and grant me the relief that was requested. Just really straightforward. Just do your job under the statute. Okay, that's what we're saying. Most of the time, the court's just going to simply ignore those letters. When the case does get listed, though, ultimately for our motion, we have to be prepared to argue persuasively and from the position of, we following all the rules here, Judge. We're doing everything right. You should give us what we're asking. But sometimes we're still going to get thwarted by slow judicial progress. They're not going to respond to it quickly enough. They're not going to do anything about it. So here's my two ideas. And this is escalating levels of aggressiveness. So idea number one is, all right, I have to be a tattletale here, Judge. You remember, the trial judges, the presiding judges, all answer to a local administrative supervisory judge. In fact, my first job out of law school was working as a law clerk for Judge Joan Mott, who was an administrative supervisory judge. And when she retired during my clerkship, I then went to clerk for the chief judge and director of the Division of Workers' Compensation. And there is a clear hierarchy. It goes chief judge and director, administrative supervising judge, trial judge. So if your trial judge is not paying attention to you, you can say, listen, I have to tell your supervising judge that you are not moving my motions, okay? If the administrative supervising judge doesn't like hearing from you, and believe me, they're not going to, right? They're not going to want to hear this. Then you can elevate the matter directly to the chief judge of the division and say, dear chief judge, we've been working on this. I've been doing everything right. I've been filing these motions, and they just don't get listed. They get adjourned for no good reason. So strategy number one is tattletale strategy. And I have to tell you the downsides of this strategy, okay? By doing this, by being a tattletale, by holding everyone's feet to the fire, you will be a pariah. I have no problem with being a renegade at all. I have no problem with this strategy whatsoever. In the case that first came up today and was my exemplar and really kind of spurred a lot of my thinking, that's my next steps in that case, right? I have to tell your supervising judge, you're doing weird things and you need to be reined in, right? That's it. That's my job in the system. You don't like it, you're gonna hate me. That's okay, we don't play golf together anyway, so that's fine. Okay, so this is strategy one. This is a pretty low stake strategy. It will be considered a renegade or rebel move, but I think it's useful, okay? The second strategy is even more renegade. This is rarely done, but New Jersey permits a party that's aggrieved to file what's called a writ of mandamus. This is a legal tool that allows an individual to compel a government official or entity to perform a duty they are legally obligated to fulfill. And this gets back, strangely enough, to the separation of powers thing. A workers' compensation law judge is not a constitutional judge. They're an administrative law judge. When I say they're not constitutional law judge, it means they can't marry you, they can't divorce you, they can't throw you in jail because they don't have constitutional authority. They're appointed to serve an administrative director of a division of an executive branch function, okay? So they're not constitutional judges, they're administrative law judges. And so what you can do when they really are not following the rules and they are refusing to grant your motions, you can say, all right, I'm going into the Superior Court, which is a constitutional court, for an order compelling the Division of Workers' Compensation to act. So this writ of mandamus basically says you, administrative law judge, as an executive functionary, have to carry out your obligations. You have to rule on these motions. And again, I'm not saying rule in my favor. Sometimes I'm just like saying, fine, say no, rule against me, say relief denied. Because then if they do that and they're wrong, I can then go to the appellate division and say, appellate division, they wrongfully denied this motion. You, appellate division, should instruct them to follow the law, right? But by not ruling on motions, by adjourning things forever, by trying to persuade the parties to withdraw motions or not pursue them, they're avoiding making a decision of yes or no, and that's their job. That's why they're judges. So this is kind of a nuclear bomb move. I've researched the law, and even though this is an allowed method, I've not found once, going back to the last time the New Jersey Constitution was amended in 1979, a single instance of anybody using a writ of mandamus to force the Division of Workers' Compensation to actually follow the law and move cases along. However, again, as someone who's standing here and fed up with how slow this system moves, I am absolutely willing to do it, and I am instructing my attorneys in the appropriate circumstances to do the same thing. All right, so that's my two crazy ideas presentation. I'm very sorry for the technical issues that we had today. Some takeaways. Vigorous discovery is important. It helps us avoid nasty surprises. It exposes potential avenues to reduce exposure, including things like prior claims or pre-existing conditions, and it's necessary to ensure justice in these cases. Motion practice, unfortunately, has to be deployed to compel discovery and move cases forward, and there are options to take it to the next level if your cases are stalling out in court. If you want someone to represent you who is going to exhaust every possible remedy to get your cases going and make sure that you're not getting exposed to either surprise or concealment, I'm happy to talk to you about how we could help you. All right. Let's move on to questions and answers. I don't know if we have any questions. I know this has been a little bit of a trying time for us to work together today, and I'm sorry about that. Okay, so I got a couple questions in here. Ron says, Greg, your video's not working. I think it's fixed now, I hope that no one's been running in and out of we have a little webinar studio here to let me know that. Joanna says, I can't see the slideshow. Ron says, now you got feedback. I know there's problems. I'm sorry about that. Ryan asked the question, Greg, I see too often where a reopener is filed, they are requesting to go for a need for treatment, and we have not received answers to interrogatories back completed, or perhaps medicals that we are waiting to get in to see what treatment is done since the last award. What recourse do we have to hold off on the exam without a judge forcing it prematurely? So A judge can't force you to do a need for treatment exam unless a motion for med in temp has been filed. Theoretically, supporting that motion for med in temp would be the medical proofs to show what they've been treating since the time of your last reopener. But again, this is a big frustration too. Where a reopener is filed, the burden is 100% on the petitioner to show that their condition has materially worsened. That's what it says in the statute, material worsening of condition. The burden is on them to demonstrate that, and once they demonstrate that, then it is the responsibility of the respondent to either be obligated for further treatment or to compensate for additional exposure. However, it is not our burden to go and prove their case for them. I do not believe in need for treatment exams, and I never recommend that we ever send a claimant back to the treater in a reopener where there's been no interim treatment. My advice would typically be to send them back to the last IME doctor that you saw or that the claimant saw. That doctor has already given us an opinion regarding maximum medical improvement and probably in the best seat to say, has this person's condition actually changed or worsened? Demanding a need for treatment exam when you haven't even completed basic interrogatory responses is just unfair. Again, it's trial by surprise. That's a fishing expedition that the petitioner's counsel is trying to take you on, and you should push back hard against that. Our position, our firm-wide position here, is that when a need for treatment demand is made in a reopener, the only thing we will do, again, after all discovery is exhausted, is send them to an IME physician who last saw them. That is our position, and I think that's the best way to defend reopener cases. So I hope that answers your question. Marie says, Greg, what's the end result of the ambassador case? Did you appeal any awards? And if so, what was the result? So the end result of the ambassador case is elevating that to the next level to make a complaint about that individual judge. And I'm going to report to you how that turns out. Iris asked the question, Greg, what to do when a judge won't consider a motion due to petitioner attorney's wife being sick? Right, yeah. Iris, I'm glad you brought this up because I have seen the most ridiculous reasons for a case to be adjourned. Look, I want to be as civil and polite as the next person. But if you're a petitioner's counsel and you can't make an appearance, that's fine. But did you even oppose the motion, right? I filed a motion to compel discovery, or I filed a motion to dismiss, or for some reason, 14 days has elapsed, you haven't responded, and then you show up and ask for an adjournment and say, oh, my wife is ill or something. Well, was she ill within that 14-day period? I want to be as considerate and sympathetic as I can, but at the end of the day, some of the excuses we've seen have been so ridiculous, and sometimes no excuse at all. Just, I'm sorry, Judge, I'm engaged in another court that day. Can you give me an adjournment? And the judge is simply granting it. That's just not fair to us. There's too much time, effort, blood, and treasure being expended in these cases for us to allow these kinds of frivolous adjournments to proceed. Now, I've had defense counsel say to me, Greg, like, that's an aggressive stance that you're taking, that you're going to challenge adjournments. What happens when you need a favor? Well, my answer is I actually do things by the book and I don't ask for favors. I've never really gotten favors. And you know, if it really was an extenuating circumstance, I'm sure maybe there could be some reason for that. But in general, if you do things by the book, you're asking for legitimate, lawful discovery. I shouldn't be needing favors from people in order to get what I'm entitled to under the statute. And so I guess that amount of, you know, righteous anger is, you know, where I'm at. And I think that the last several months, maybe the last year, we've seen the division slow down and things slow down tremendously. I do think one of the things that we've observed is that during COVID, when they went into lockdowns and some of the judges became remote, some didn't, some of petitioners' attorneys decided, oh, wow, the courts are going remote. I can take more cases all over the place, and maybe they're spread too thin. And that's sort of one of their challenges. We never adjourn a hearing. We show up for all the hearings. All the hearings take place on our regular list date. So I'm never asking for an adjournment, nor do I want adjournments. Ryan asks a follow-up question. Greg, so on a reopener, once your investigation is completed, you don't send them back to the authorized treating doctor to see if they feel they need further treatment? No. Why would I do such a thing? No. My investigation completes, so I get my answers to interrogatories. I get copies of all interim medical. Often there are none. And I say, well, there's no basis for this demand. The only thing I'll do is I'll send you back to the last IME doctor who saw them. So then your question continues. Greg, you're saying you'll send them to the IME doctor right away? Yes, the answer is yes. If they feel they need for further treatment needed first. Now, will petitioner counsel accept that report if they say nothing is needed and move to a Section 20, or do they force another opinion? So it's going to depend on the case, right? Some petitioners counsel are only making the need for treatment demand to you, simply so that as soon as you say no or send them to your IME doctor, they're going to send them out to their friendly physician who's going to say their condition is so much worse and they need so much more compensation. So there is an element of gamesmanship to this that we cannot be immune to and pretend that all of these doctors are both independent and impartial. That's just simply inaccurate. All right, a couple more questions here. Let me go down the list. Travis wrote, Greg, comma. I think if there was the rest of your question there, I don't see it, Travis. Sorry, it's missing. All right, and it looks like you might be having trouble typing your questions in because the rest of them are not coming through. All right, let's close it off here. I think this was it was a challenging presentation, and I'm sorry for that because of the technical challenges. We'll certainly get that worked out before next month's presentation. I hope everybody has a great week, a great rest of your month. Happy Valentine's Day. Thanks for joining us today. If you're rooting for the Eagles or the Chiefs, I hope your team wins. Have a great weekend, everybody.